News where you live. 5 News starts with breaking news.
Breaking right now at noon, after a battle in the state Supreme Court, we're learning abortion access will not be on the ballot in Arkansas this November. The ruling came down just after 10:30 this morning in a 4-3 vote. State Supreme Court justices say that signatures gathered by paid canvassers representing Arkansans for limited government will not count. Last month, Secretary of State John Thurston disqualified the Arkansas abortion amendment, saying the AFLG did not submit proper paperwork by the July 5th deadline. AFLG used paid canvassers along with volunteers to collect signatures. The Secretary of State claimed state law requires the sponsor of a ballot measure to sign a statement saying it gave paid canvassers the Secretary of State's handbook and initiatives and referenda. AFLG then sued the Secretary of State's office, calling the decision unlawful and robbed voters of the opportunity to approve or deny the amendment themselves. The case boils down to signatures and who can be determined as a sponsor of an amendment. The document AFLG submitted back in July was signed by Allison Clark. Clark is a staffer for the company the abortion rights group hired to collect signatures. Thurston says that violates state law that has led to this moment. The Arkansas Supreme Court justices ruling that the abortion measure will not appear on the ballot this fall. In the majority opinion, Associate Justice Rhonda Wood writes, quote, "The precedent and result reached in Miller applies. The signatures collected by paid canvassers could not be included in the Secretary's initial count, and the petitioners were not entitled to a cure period or any other relief. Again, this mirrors our prior precedent." Both Chief Justice John Kemp and Karen Baker wrote in disapproval with the majority's opinion, saying in part, quote, "I would be remiss if I neglected to highlight these allegations as the differing treatment of these petitions is alarming. The majority has succeeded in its efforts to change the law in order to deprive the voters of the opportunity to vote on this issue, which is not the proper role of this court." If passed, the Arkansas abortion amendment would have stopped the state from banning abortion in the first 18 weeks of pregnancy or in the instance of rape, incest, and fetal anomalies. Right now, we're still working on getting a reaction from Arkansans for limited government, as well as state leaders, including the Attorney General and Governor. Once we get those reactions, we'll have the latest update right here at 5 News. You can see those starting at 4. You can also find those on our website and our free 5 News app.